I'm simply saying that there must be a case then, you know, that somebody will take up or bring forward before the Code of Conduct Tribunal. In this case, the Code of Conduct Bureau brought up this case by itself. Are you then saying that the Code of Conduct Bureau or Tribunal is subject to the whims and caprices of the people who made that, you know, particular vow? That's what I'm asking.
Well, let me also make it abundantly clear that it is almost impossible to say that there is anybody who cannot be influenced, either directly or indirectly. And if the Code of Conduct Tribunal is doing its work as a neutral body just to prosecute crimes or defaults by public officers, when the issue of the procedure came up, the reasonable thing to do, like I said before, is to stay trial and wait the outcome of that objection. But that they went ahead to even issue a bench warrant when the crux of the matter has to do with their powers and jurisdiction to try that charge. I think that they misfired and they sold themselves out.
Mr. Tina, let me read something to you from the Act about the issuance of the warrant that you just read. It says, notwithstanding the provisions of any other enactments conferring power to search, if the chairman of a tribunal is satisfied that there is a reasonable ground to suspect that they may be found in any building or any other place whatsoever, any books, records, statements, or in any form which is or may be material to the charge or any trial under this Act, he may issue a warrant under his hand authorizing any police officer or member of the security agencies to enter into it. Does that make sense to you?
That will only apply when the trial has commenced properly before you and you have assumed jurisdiction. Then you have the powers to order for either a search or removal of any material that you think is related or important to the trial. But that cannot apply in the circumstance under which we are discussing.
Mr. Chinda, I asked you a question earlier, and my colleague also asked a question similar to it. I asked you a question that, would it have been wrong for the Senate President to have responded to that summons? And my colleague asked you a question. Why is it that whenever politicians have questions to answer, they term it to be political? Do you think that Nigerians are not how do I put it now, are not knowledgeable about what's going on or do not want to know what's happening behind the scenes?
Now, in response, I actually answered that question when I said that, yes, the Senate President has two options, either to appear before the tribunal and raise his objection, which is exactly what you're asking. He also has a second option in law.
Yes, you did.
To go to a court to ask for an administrative interpretation of the actions, which he chose to do. There is nothing wrong with what he has decided to do. If you have two options, you can choose whichever to apply in your case, particularly when you feel more comfortable with the second option. He chose to do that. On the second issue, politicians always crying foul that they are being witch hunt. Let me make it clear again that for most politicians, you find out that, yes, they could have committed a crime, but that crime most often will be provoked by an opponent, somebody who wants to run you down. And then he will not only provoke that issue and allow trial to go on naturally, he will be behind the scene to ensure that that trial is killed. And that's why you hear politicians always crying foul.
So if we have a case of options here, you said that the Senate President had a second option and he took the second option available to him, yet you accuse the Code of Conduct Tribunal of bias because it had two options and took the options it chose in terms of issuing the bench warrant. Can we really say that we can, you know, criticize the Code of Conduct Tribunal for taking the option that was also open to it and allowed by law?
The option I talked about is open to Senator Bukola Saraki, not the Code of Conduct Tribunal. When Senator Saraki chose the option to approach the Federal High Court, the reasonable thing for any judicial panel to do when your jurisdiction is challenged is for you to stay further proceedings and await the outcome of that challenge. But the Code of Conduct Tribunal in this case went ahead to issue a bench warrant.
It's interesting to note, Mr. Honorable Chinda, just a moment. It's interesting to note that even lawyers are not agreed in terms of, you know, whether or not it was the jurisdiction of the code of conduct that was under, that was being challenged here. And they say it's quite interesting that the matter has gone on appeal. But I was talking about the options available to the Code of Conduct Tribunal when it was talking about the presence of the Senate President. The lawyers of the Senate President had argued that their client did not need to be there because he was challenging certain things. But they also promised to bring him to the Code of Conduct Tribunal on Monday, that's today. But the Code of Conduct Tribunal decided otherwise, that they were going to force their hand instead and issued a bench warrant. Those were the two options available to the Code of Conduct Tribunal, and they picked the one that they wanted to pick. How then can we interpret that to mean bias?
Now, clearly, the essence of a bench warrant is that the person cannot be gotten willingly, or the person has refused to appear before you and is likely to abscond. So you issue a bench warrant for his arrest and for him to be brought before you. But when you have a lawyer appearing for the accused person before you, and the lawyer has undertaken that his client will be in court, the bench warrant at that stage was completely unnecessary. Particularly, you also consider the persons involved. Whether you like it or not, it comes to play. And that's why you have even issues of bail on personal recognition. Number 3 citizen of this country, even where he has committed an offense, can still be granted bail on personal recognition. So the issue of bench warrant, I think that is an overkill, and it clearly betrays the emotions of members of the tribunal.
Very quickly, in closing, in wrapping this up, what would you be proposing as a way to an end to all of this?
I propose that, firstly, like the Leonard Silk advised, the CJN has to come in to interpret the law clearly for parties to know their rights and their powers. And then let me also ask that the President of the Federal Republic of Nigeria should look inwards. Let him not adopt the Pontius Pilate style of washing his hands off. He should look inwards. If there is any iota of political trial or political prosecution in it, it should be completely removed from this whole trial. Again, let me state it abundantly that we are supporting the drive against corruption, but we will also not allow ourselves, that is politicians, to use that in order to truncate our democracy.
Many thanks, Honorable Kingsley Chinda, for speaking with us on Sunrise Daily.